Hello and welcome to another presentation. In this presentation I'm going to cover a rough outline of what your options would be if you have to file an appeal to your council tax hearing, if we want to call it a hearing. What are my options? If you lost your magistrate's court case regarding council tax in the UK, you have several options for further action. Here are the key steps and relevant provisions. You could appeal to the High Court on a point of law. Okay. You can appeal to the Magistrates Court decision to the High Court if you believe there was an error in law. This is known as a case-stated appeal. The relevant statute is Section 111 or 111 of the Magistrates Court Act 1980, which states any person who was a party to a proceeding before a magistrate's court or is aggravated by the order, determination, or other proceeding of the court may question the proceeding on the grounds that it is wrong in law or in excess of jurisdiction by applying to the court to state a case for an opinion of the High Court on a question of law or jurisdiction involved. You must submit this appeal within 21 days of the magistrate's court decision. So that's one option. Now you can only pick one option of the three, or actually two. You can pick one option out of the three for a final verdict. Let's put it that way. The other option is to go to a judicial review. If you believe the decision was made unlawfully or there was a procedural error, you can apply for a judicial review. This must be done within 3 months of the decision. Judicial review is governed by Section 31 of the Senior Courts Act 1981, which states the following. An application for judicial review shall be made to the High Court, and the High Court shall have jurisdiction to hear and determine such an application. So that tells you where a second avenue that you can pick. The third option, if you don't want to go down that road, if you're unable to pay council tax or disagree with the amount, you can contact your local council to discuss a payment plan or potential reductions. Councils often have a discretionary power under Section 13A of the Local Government Finance Act to reduce or waive and eliminate your council tax altogether in cases of financial hardship. Those are your three basic options if you want to appeal a decision from the magistrate's court regarding council tax. I'm going to explain a little bit more in the next few slides. The other option, okay, the fourth option if you want to go down that, if you believe the council tax has acted improperly or not followed proper procedures, you can file a complaint with the local government and social care ombudsman, LGSCO, and the LGSCO can investigate and recommend actions if they find the council is at fault. This is probably one of your weakest options, in my opinion. I don't know, I've never tried it, but I would suggest that an ombudsman probably doesn't have the authority to sway a court. Now, some may argue that the magistrate's operation in so-called court is not a lawful court, and you would be perfectly right. I am investigating another option, but until it's been proven, I will refrain from speaking about it. So you're basically left, if you contacted the council and they won't talk to you or won't reduce your payments, you really, under the law, have two options. You can do an appeal for a case stated, as I originally stated, or you can do a judicial review. If you have done your case under a judicial review, okay, and you lost a judicial review case challenging the decision of the magistrate's court in the UK, you can't file a separate appeal in the Crown Court or other appeals court after that. Here are the key points. Appeals from magistrate's court in criminal cases normally go to Crown Court under Section 108 of the Magistrates Court Act. Now keep in mind that what the Magistrates Court has done, much of it is actually criminal. So therefore it would go under Section 108 of the Magistrates Court Act, and I've given you a list of references which will follow in this presentation under points 1, 2, and 3. This is an appeal by way of rehearing the entire case afresh. Okay? Judicial review is a separate mechanism for challenging the lawfulness of the magistrate's court decision rather than the correctness of the decision itself. You have to be very careful what you do here. If it goes to the High Court rather than to the Crown Court, if you lose a judicial review in the High Court challenging a magistrate's court decision, you cannot then appeal to the Crown Court as well, and I've given a reference under point 12. The judicial review proceeding finalizes the challenge to the magistrate's court decision. The only further avenue after losing a judicial review would potentially be to appeal to the High Court for judicial review decision itself to a higher court, like the Court of Appeal, but only on limited grounds and with permission. And I've given the reference under point 11. In summary, once you have taken the judicial review route and it is concluded, you cannot then separately appeal to the original magistrate's court decision to the Crown Court as well. Okay? The judicial review finalizes the challenge to that decision, subject only to any further appeal strictly about the judicial review itself. And I've given points 1, 2, 3, 11, and 12. Now, I do happen to know in a certain particular case that the judicial review case is in fact flawed, and I'm willing to take the appropriate steps to address that issue. Now, I don't know your specific case, so I'm going to give you a couple of case examples. Nicholson versus Tullingham in Magistrates Court, 2015. This case involved challenging the costs added by the local authority for the liability order. The High Court outlined that a magistrate's court must be satisfied that the costs were actually incurred and were reasonable. Now, in many cases, I know that when you get a magistrate's court order, they charge you somewhere between 30, 40, maybe 60 or 70 pounds to hear that case, when the actual cost of the hearing is as simple as sending an email, because the courts have confirmed it's all done electronically in bulk. So I don't think it costs them anywhere near 20, 30, 40, 60, or 80 pounds to press send on a computer. So that would be one ground for an appeal. R on application of Newham, LBC, versus Stratford's Magistrates Court, 2008. This case confirmed that high bar for quashing the liability order required a genuine and arguable dispute about the liability, substantially procedural errors, and prompt application. Again, I know of a case that there's issues with the liability order, given the fact that A, it's not issued by a court, B, it's done in bulk, you're told not to attend a court hearing, the court hearings are done in private, which is another violation, and a number of other issues. So this could be a potential argument if it's applicable in your case. I bring up R versus Brighton and Hove City Council versus Brighton and Hove Justice and Hamden, 2004. This case emphasizes the need for promptness in applying to set aside a liability order. So you can ask for a liability order to be set aside while it goes under judicial review, and you would typically do that right after your magistrate's court hearing, and you would talk to the magistrate's court, and usually it goes through the legal advisor first, and at the same time while you've done that, I would be either going down the judicial review or filing for an appeal under case stated. I have given the list of references. You're happy to stop this presentation and write them down. I will leave the screen on this screen for about 10 seconds. Here's the second citations. Third list of citations. Fourth list of citations.